You will often hear a law in Massachusetts referred to as the dog bite statute or the dog bite law. That's chapter Mass General Laws 140 and it's section 155. And it imposes strict liability on the owner or keeper of a dog who causes injury. Now, we can get into the definitions of owner or keeper, but let's just basically apply common sense to that and say, what does that statute set out? What does it require or not require? The first thing that you notice about that statute is that it doesn't speak in terms of negligence or a lack of reasonable care or anything of that nature. And that's because in the context of these injuries from dogs, strict liability is imposed. What is strict liability? It simply means that you need not prove negligence. I've tried a few of these dog bite cases, and in fact, the cases go to the jury on the basis of the statute. They don't even have to go at all on the basis of any kind of allegation or assertion of negligence. Simply the fact that there was an injury and the fact that the owner or keeper had this dog, regardless of the propensities of the dog, that is enough for compensation under a strict, and I say accurate, reading of the law. There is an additional caveat in the law that says that the person shall not be teasing, tormenting, or abusing the dog. And someone under 7 years of age is presumed not to do so. But anyone else where that allegation is made by the defendant, anyone else would have to be deemed to have done so, and there would have to be evidence along those lines. One thing additionally I'd like to say about Chapter 140, Section 155, is that there need not be a bite by the dog. People, and I started this video by saying the dog bite statute, people refer to it as the dog bite. But it could simply be a collision between a dog and someone, and some sort of bumping. There need not be any kind of bite. Obviously, the bites generate typically far more serious injuries. But I think we should all understand that the statute is broad in that respect. It is not limited to biting. Obviously, these are not pleasant injuries, and then you say to yourself, well, where is the money coming from? It would come from the homeowners insurance policy. There are some dogs that are accepted from insurance. However, the vast majority of dogs are covered under one's homeowners insurance policy. And when I use the term one's, I mean the owner or keeper of that dog's insurance policy, not your own dog who, God forbid, bites you or a child or something like that. I'm speaking about basically a third-party owner or a third-party keeper whose dog causes damage, again, doesn't bite. There are, of course, various leash laws, and you may have thought at the outset of the blog I would speak to that. Those leash laws really don't govern the law here in this context. Rather, what governs is that an injury occurred from a dog and that the victim was not teasing, tormenting, or abusing the dog. Again, this is one area where negligence in the personal injury context need not be proven. Thank you.